Ms. Hunter, state your name for the report.
Commissioner.
Your Honor, we need an adjournment. With your permission, we need the BP gas station cameras where this incident allegedly took place. I know I'm here.
Are they mine? What do you mean you need? Oh, wait. Okay, so you need an adjournment
Yes.
and you want the BP camera.
Yep.
I just said, okay, will that work? I can get you the adjournment. Is there a problem with the?
We'll look into it and see what we can come up with.
Okay. Is it the one up here?
One by La Forge. Here in River Drive.
Okay, so it basically you're requesting some time to check into whether or not the third
The
party.
prosecutor.
And yeah.
It's right at the corner of Ann Street, here in River Drive, La Forge, that whole area there.
Okay,
Back on the request, I'll follow up on it.
okay, very good. Okay, you don't have anybody here with you, do you?
Yes, in spirit, I do.
Okay, how do we? No, anyway.
Know the good dates and the bad dates.
Is that a list?
As long as you go more than 1 week.
As long as they go more than 1 week?
Yes, sir.
Okay.
So,
Then April 2nd, I hear you're available.
thank you, Your Honor.
Thank you.
Time?
Oh, I said it at 9 and then
Okay.
the time, and you're not gonna pay attention to that anyway, because you don't know how to open email. Staff will get it and they'll tell you when you gotta go.
You're right again.
I know. Thank you.
Have a good day.
You do the same. Court calls the case.
Amended motion. Thank you, by the way, for hearing this on such short notice. Mr. Warren, been in custody since October, correct? Yep, been in custody, since October 15th of 2025. He has, a pretty severe mental illness and he's been deteriorating over the last month or so. He's been in protective custody for over a month, and then I think he was released recently from protective custody. And then either way, it got pretty bad where he was starting to self-harm. He was trying to jump off the ledge and hurt himself. I got a call from Dr. Maiman, and who's a wonderful individual. He's very difficult to get a hold of. So when I got a call on my cell phone over the weekend from Dan Maiman at the jail, expressing concern, asking me to try to come in and modify Josh's bond so that he could be admitted to patient hospitalization at the hospital. Obviously, I took it very seriously. I thereafter contacted the people's representative, Mr. Cook. He was very gracious, understanding the situation, also sort of wanting to do something to get Josh placed in patient hospitalization. I filed a motion on Monday. Your Honor asked for specific authority that I was unable to provide, showing that Your Honor had jurisdiction or had the power to force the forensic center to accept him. Thereafter, after speaking with Dr. Maiman, I amended the motion seeking different options. Dr. Maiman, who is available today to be here, he's at the jail in a staff meeting, but he can be here in several minutes time. He said, if Your Honor wants me to make that happen. What he is suggesting, and I am also suggesting as Josh's attorney, is that his bond, which is presently at $25,000 cash or surety. I suggested in the motion, it's a PR or 8%. Cook dutifully told me that because he has a prior charge that he can't be released on a PR, that there would need to be some monetary component to the bond. And Dr. Maiman thinks that we can take him right to that if the court were to do this and
so in the end, the judge lands on a structured release, bond reduction, GPS tether, and strict conditions. It's a decision that tries to balance law, safety, and humanity all at once. But here's what I want to know. Did the court do enough? Or should mental health cases like this bypass the standard system entirely? Drop your thoughts below, because cases like this don't just test the law, they test the system itself. And here it is, the backup plan. GPS tether, home confinement, third-party supervision. This is the court's way of saying, we'll help, but with strings attached. It's actually a very common compromise in situations like this. But let's be real. Does home confinement truly protect someone struggling this deeply? Or is this just the system's safest middle ground? This is a pivotal legal moment. The defense is essentially proposing a direct pipeline from jail to hospital. That's not standard, and it raises a key legal tension. Courts can set conditions for release, but they can't always force medical facilities to accept someone. So now we're watching a balancing act, public safety versus urgent medical intervention. If this works, it's a lifeline. If it fails, he goes right back into the same environment that caused the crisis.
The jail take him right to, I think at first he wanted U of M, but he's since spoken to St. Joe ER, where he could have it has done in the jail has done in the past. Josh is also under a mental health court treatment order in Washtenaw County probate court. The issue there is that it's not yet, and it probably will be, an order for inpatient hospitalization. It's an outpatient order, an AOT, I assume. And so that does not allow him to just put him right in. I'm not exactly sure. I'm not in that case. I need to see. I'm probably going to enter an appearance in that case. There is a couple issues with just, if Your Honor was inclined to just say, yeah, that's great, Margolis, let's do that, which I'm not suggesting Your Honor is at that point or would be. But there's another case where there's $1,000 cash bond. It's a larceny matter out of this court as well. It's an old case, a 2022 or 2023 case. And I just mentioned that to Mr. Cook. Secondly, there is a parole hold on Josh. So whatever the court may or may not do, that is something that I and Josh are going to have to contend with as well. I've spoken at length with Agent Cromwell, who is his parole officer. He is aware. Josh was in prison and they actually paroled him early prior to his mandatory minimums on a D47, D42.
It was a little thing, D42.
D42, which is a mental health parole. So that's where we're at right now. Agent Cromwell did say that he would seek to turn it around relatively quickly once he hears from me and or this court. Typically, he says it takes him about 4 days to process. Like he'll put his stuff together, his investigation, he sends it up to Lansing. Lansing turns it around in typically 4 days, 3 or 4 days. He thinks he can do that quicker. He knows Josh, he knows the situation. Last thing, Your Honor, I brought, so in my motion, I suggested different potential options for the court to consider if he wasn't able to be admitted immediately to inpatient hospitalization, where I suggested maybe consider having the bond reduced and allowing him to get out on a GPS tether, house arrest, and a third-party custodian. Miss Witherspoon, Tammy Witherspoon, who is Josh's landlord and knows Josh, godmother, thank you, Josh, is here if the court wanted to speak to her on the record, off the record in any fashion. And I thank you very much for coming, man. So that's the short of why we're here today, Judge. It doesn't seem that the jail is adequately equipped to handle the illness that Josh has been displaying, and the present bond makes it unable to have him admitted to hospitalization.
Mr. Cook, you respond.
Briefly, Your Honor, as I told Mr. Margolis in different language with the same effect, my goal is always the protection and well-being of the people of the state of Michigan. This individual is one of the people of the state of Michigan, so I want to make sure that he is in an environment where he is not at risk of serious harm or potential death. I don't know what the solution is as far as how to get him that treatment. I agree that he needs treatment in some form. And as long as he is getting that treatment and he's getting the help that he needs, I'm fine with whatever resolution or order that this court puts in place.
Well, simply put, Mr. McCullough, you were looking for a release on a GPS tether to home confinement with certain exceptions to that home confinement.
Only if, I mean, my ideal world is for him to be released, not to home confinement or GPS tether, but to the, inpatient to St. Joe
So in the end, the
ER,
judge
and then
lands
have
on a
him
structured
evaluated
release,
where
bond
Dr.
reduction,
Maiman and I
GPS
are
tether, and strict
relatively
conditions.
confident.
It's a decision that
he's-
tries
But
to
then-
balance law, safety, and humanity all at once. But here's what I want to know. Did the court do enough? Or should mental health cases like this bypass the standard system entirely? Drop your thoughts below, because cases like this don't just test the law, they test the system itself. And here it is, the backup plan. GPS tether, home confinement, third-party supervision. This is the court's way of saying, we'll help, but with strings attached. It's actually a very common compromise in situations like this. But let's be real. Does home confinement truly protect someone struggling this deeply? Or is this just the system's safest middle ground? This is a pivotal legal moment. The defense is essentially proposing a direct pipeline from jail to hospital. That's not standard, and it raises a key legal tension. Courts can set conditions for release, but they can't always force medical facilities to accept someone. So now we're watching a balancing act, public safety versus urgent medical intervention. If this works, it's a lifeline. If it fails, he goes right back into the same environment that caused the crisis.
If he's not admitted.
That is why I had this fallback request, that some sense of security for the court and for Mr. Cook, that, all right, if we didn't get him admitted right away, then we would at least have him on a tether, on confinement, and we had a third party custodian. That's why I suggested those as perhaps the alternative if we weren't able to get him taken from the jail.
Well, but if I release him, there'll have to be a cash component. But if I release him on a GPS tether with home confinement, but with the exceptions for necessary medical and mental health treatment, why wouldn't that accomplish what you're saying?
I think it will. I don't know if I'm sure of your question. I mean, that's why I wasn't so.
I mean, you're saying to try to release him so that he goes inpatient someplace right away. I'm saying I don't think that's going to happen. So, and then if he is an accepted inpatient, he would go into home confinement. I'm saying, why am I going through all of those steps? Why wouldn't I just release him to home confinement? If inpatient's the appropriate treatment for him, then that's where he would go, to inpatient, because that could be mental health treatment.
No, I think that's the proper avenue, and it probably was not said that way as eloquently in my motion.
And how much do you say can be posted on his behalf, you think?
I mean, he has a family trust that hires me. It's a special needs trust, and so they release a certain amount at a time. I don't necessarily want to make a representation of how much. I was going to suggest that it be either reduced to like Raymond 10,000, 10%, 5. I would leave it to Mr. Cook's and the court's discretion in that respect. But I know that at the present amount, it's not something that they're willing to do.
Your Honor, I don't have a specific amount that the people are requesting for the monetary component. I just was bringing to Mr. Margolis' attention my understanding of the statute that there's a requirement for prior felonies.
Correct. So what I will do is I'll order that the defendant can be released on a $25,000 10% bond. he must be on a GPS tether prior to release. The GPS tether will be a home confinement to the address. Give that to me. Let's see, on Valencia Circle. And that the defendant, there would be certain exceptions for and that he would be under the supervision of his godmother, Tammy Weatherspoon, at that address. And that the defendant would have to remain at home except for necessary medical and mental health treatment, inpatient treatment, court proceedings, and appointments with counsel.
Not right now. Oh, well, he has to use a lot of good outpatient treatment in AA meetings. I'll deal with that. I'll speak to him and see if it's probably covered under the order, and we'll speak to any tethered agent if and when that time comes.
Okay. All right. So that would be the order of the court, and it doesn't quite fit with the order that you submitted to the court, but Mr. Margolis, to prepare an order and send it to my office, I'll sign off.
I was ready to do that today. I think I'm having internet issues, so I will go back.
So in the end, the judge lands on a structured release, bond reduction, GPS tether, and strict conditions. It's a decision that tries to balance law, safety, and humanity all at once. But here's what I want to know. Did the court do enough? Or should mental health cases like this bypass the standard system entirely? Drop your thoughts below, because cases like this don't just test the law, they test the system itself. And here it is, the backup plan. GPS tether, home confinement, third-party supervision. This is the court's way of saying, we'll help, but with strings attached. It's actually a very common compromise in situations like this. But let's be real. Does home confinement truly protect someone struggling this deeply? Or is this just the system's safest middle ground? This is a pivotal legal moment. The defense is essentially proposing a direct pipeline from jail to hospital. That's not standard, and it raises a key legal tension. Courts can set conditions for release, but they can't always force medical facilities to accept someone. So now we're watching a balancing act, public safety versus urgent medical intervention. If this works, it's a lifeline. If it fails, he goes right back into the same environment that caused the crisis.